Everything explained in this video is summarized from the CoinMarketCap, and also please don't forget to like and subscribe to my channel for future XRP news and some other cryptocurrency news in general. Now take a look at this. Former White House official says SEC has dropped Ripple case. He is a former director of communications for the White House, Anthony Scaramucci, and he believes that the Securities and Exchange Commission has dropped its investigation against Ripple. This audacious remark was made by Scaramucci during a recent interview that was conducted for the Wolf of All Streets podcast. During the conversation, Scaramucci and Scott Melker, the host of the podcast, discussed the regulatory framework associated with the cryptocurrency business, as well as Donald Trump's aspirations to support cryptocurrency. SEC drops lawsuit against Ripple? Several other events were also reviewed, most notably the decision made by the SEC to withdraw its lawsuit against businesses associated with cryptocurrencies. Melker brought attention to several recent cases that the Securities and Exchange Commission, SEC, has decided not to pursue. These cases include Consensus, Gemini, Uniswap, Coinbase, and Robinhood. Scaramucci, on the other hand, chimed in and suggested that he should include Ripple on the list. In answer, Melker repeated, "Yeah, that's right," hinting that the Securities and Exchange Commission, SEC, may have decided to abandon the action against Ripple. The Securities and Exchange Commission, SEC, has not yet made an official announcement regarding its decision regarding the Ripple lawsuit. This is because the matter is still being considered by the Court of Appeals for the Second Circuit. The Securities and Exchange Commission, SEC, has taken a pause and dismissed proceedings against prominent cryptocurrency companies such as Binance and Kraken. Ripple was accused by the Securities and Exchange Commission as early as December 2020. However, the case is still ongoing. Ripple case is the only factor postponing it. According to the opinions of legal experts, the verdict that was handed down in July 2023 makes it more difficult for the SEC to dismiss the Ripple litigation. It is important to keep in mind that the judge decided that Ripple's programmatic sales and other distributions of XRP did not constitute securities. On the other hand, she discovered that Ripple had breached the law by doing business with institutional investors during its initial sales. The following year, the judge imposed an injunction that banned Ripple from selling to institutional investors without first obtaining the authorization of the SEC. In addition, the judge levied a fine of $125 million against Ripple for this infringement. Attorney Jeremy Hogan, a partner at the Hogan & Hogan legal firm, stated in a recent X thread that the injunction is the primary reason why the Securities and Exchange Commission has not yet dropped the appeal on the case. He highlighted by him how difficult it would be to reverse the appeal, and he mentioned that such a move might potentially push the case back to April or May the next year. By Rule 60 of the Federal Rules of Civil Procedure, he ruled out the prospect that Ripple would reverse the appeal. According to him, the only way for Ripple to reverse this verdict is for the company to work along with the SEC to submit a carefully worded motion. Jeremy Hogan, an attorney who advocates for XRP, discusses why a resolution in the SEC case against Ripple has been postponed on multiple occasions despite the regulator's recent turn toward cryptocurrency. With swift actions to halt or dismiss pending cryptocurrency proceedings, the Securities and Exchange Commission has made it very obvious that it plans to take back its crypto regulation by enforcement campaign over the course of the previous several weeks. Despite this transition, there is one case that has continued to linger: the SEC prosecution against Ripple, which has been ongoing. Still, the question is, why is that? One legal expert who has been following the issue very closely has now proposed a possible explanation for the situation. Is there a case for blame? A pro-XRP attorney named Jeremy Hogan has made an effort to explain why a settlement of the SEC case against Ripple continues to be delayed despite the regulator's recent turn toward cryptocurrency. In a lengthy thread that was posted on X on Sunday, March 2nd, Hogan argued that the injunction that Judge Analisa Torres issued on Ripple in her court order from August 2024 was the most likely cause for the delay. To be more specific, Torres decided that Ripple was not permitted to provide XRP to institutional investors without first obtaining an exemption from the government. It is possible that the case, which is presently being appealed, will continue until April or May of 2025, according to Hogan, who believed that Ripple would not like to have this injunction. However, he also mentioned that abolishing it would be a difficult effort. The attorney brought attention to the complexity of the matter by pointing out that the conventional process of obtaining relief from judgments, as outlined in Rule 60 of the Federal Rules of Civil Procedure, may not apply to the Ripple case. Rule 60 permits the granting of relief from a judgment if an error or new facts are discovered. Even though Ripple may use the SEC's shifting crypto rules as new facts, Hogan points out that the decision was based on the Howey Test Supreme Court jurisprudence, not the SEC's rules. The odds of Ripple, Hogan asserts that Ripple only has one shot at removing the injunction from the court's jurisdiction. In his explanation, he stated that the company may try to wager on the judge's discretion by submitting a very carefully worded motion that would need to be reviewed by the SEC. On the other hand, he anticipates that these procedures will take some time, which will result in his resolution estimates of April 2025 and May 2025. The attorney emphasized that the presumed backing of the Securities and Exchange Commission, SEC, is a significant aspect that has the potential to tilt the scales in favor of Ripple. In a lawsuit filed in December 2020, the Securities and Exchange Commission, SEC, claimed that Ripple's transactions of the cryptocurrency asset XRP constituted unregistered security offerings. According to him, this is something that might take place without the need to wait for the regular process of unlocking the escrow account. This disclosure is particularly noteworthy because it comes in the wake of official confirmation from President Donald Trump of the United States that the nation will establish a cryptocurrency asset reserve using XRP and other tokens. Several individuals are speculating on how the government could build the suggested reserve by making use of the XRP coins that Ripple is holding in escrow, while XRP enthusiasts are celebrating the news. A clear path for this process to take place is suggested by XRPL validator VET amid this event. VET suggested in a tweet that Ripple might carry out a single transaction to transfer control of its escrow account to the United States government or any other organization. According to him, Ripple could essentially grant complete control over the escrowed assets if it were to set the regular key of the XRP accounts that were holding the escrowed monies to the account of the United States government. His emphasis was placed on the fact that the procedure is not complicated and that it could be finished in a single XRPL transaction. By utilizing this approach,